and we're recording. Excellent. So welcome everyone to our SAIFAC seminar today. Delighted this time that we've got two of our SAIFAC researchers who are going to be presenting and on their current research. Before I introduce them and the topic, I'll just mention to you our forthcoming seminars. Next week, we have one with a special rapporteur on the right to health with the International Commission of Jurists. That will be on Wednesday and in an evening seminar, 5:30. And the following week, we actually have two for the end of term. We have one on the Wednesday evening seminar, which will be on the increasing recognition of the rights of animals in litigation around zoos in courts around the world. It will be a comparative panel. That will be a slightly longer one of 2 hours. And then we will have the following day, our third part of our climate change series about behavioral change from a social psychological perspective. So we've got an exciting range of seminars, and we look forward to having you join us online for those seminars. But without further ado, let me introduce our topic today. And we kind of looking at the fascinating remedial developments in relation to courts. And we know that the backdrop is in many ways the lack of capacity in the state in South Africa, often the inability to fully comply with court orders or to realize their responsibilities. And so increasingly, we've seen more interventionist remedies taking place by the Constitutional Court and, in fact, other courts as well. And so we thought it's a really interesting, and drawing on the research of our researchers, to focus on supervisory jurisdiction, and in particular, the role of court-appointed experts and monitors, right? And our speakers will engage a little bit more in detail with that. So without further ado, we're going to start with Helen Taylor. Helen is now, as I mentioned, a researcher at SAIFAC. She completed her BA Honours and LLB at Stellenbosch. She did her BCL and DPhil at Oxford, and actually in this area on remedies. Helen closer clerked for Justice Johan Froneman, who's recently retired, and also has just finished a stint before coming to us as a researcher at the, well, it's known as the State Capture Commission. So without further ado, I hand over to you, to Helen, for about 20 minutes, and then Robert will speak for about 20 minutes, and then we'll open up for questions. Okay, so over to you, Helen.
Great, thank you, David. Good afternoon, everyone. I'm just going to share my screen with you. Which I hope you can now see.
Yes, we can now see it.
Great, fantastic. Good, fantastic. So thank you very much, David, for the invitation to speak. For me as a new researcher at SAIFAC, it's great to immediately have this opportunity to share some of my work and get some feedback on it. Thanks to Naomi and the team at SAIFAC for organizing the seminar, as well as, of course, to everyone who's joined us, taken their lunch break to join the seminar and give their feedback. And it's particularly special, I think, for me to be presenting alongside a colleague at SAIFAC, Roper, whose work in this area is really, quite literally hot off the press. So it's a real privilege to do that this afternoon. The emerging use of court-appointed experts and monitors is an exciting area, as David said, of our law. It's fast developing, but it's also controversial. So hopefully Roper and I this afternoon can spark some debate, which will test our assumptions and thinking about remedies. And we look forward to your questions as we go. But I'll start with something that I hope we can all get behind, which is to affirm the importance of remedies for the full realization of rights. So in court judgments, whoops, sorry. Apologies. So in court judgments, remedies are seldom given the same time and consideration as rights. Judgments frequently devote dozens of pages to their reasoning about establishing a breach of a right. while the remedy often just features as a postscript or an afterthought. It reads as if it's tagged onto the end of a judgment in a few lines, or perhaps if we're lucky, a few paragraphs. And I say this not just as the gripe of a researcher of remedies whose subject matter is relegated to the tail end of judgments. Rather, I think that there are important principled reasons why remedies should be given greater attention and priority, both in judicial reasoning, but also in academic work. And so this is very exciting today to be able to speak about that. This is because I think in an important way, remedies are the way that courts speak. They speak through their remedies. And I don't mean this just symbolically, but also in a very tangible and practical way by giving effect to rights. So in this sense, we can say that remedies concretize rights, or as the former Chief Justice of Canada has more elegantly put it in her extrajudicial writing, she says that rights and remedies are interwoven in the single fabric that we call justice. But remedies don't only operate at this exalted level of vindicating rights. They're also in many ways a reality check on rights. And this is often a hard, resistant, even dysfunctional reality. And by this, I mean that when courts craft remedies, they are confronted with all the institutional problems, the political blockages, the social complexities that might underlie a human rights violation, and which therefore may also jeopardize future compliance efforts by the court. And I think this is particularly true in the context of systemic failures by the state to fulfill its human rights obligations, which is, of course, the focus for our seminar today. I say this because systemic human rights violations pose distinctive challenges for our courts, both in terms of remedial formulation and remedial implementation. Firstly, in relation to remedial formulation, this not only involves formulating a plan for systemic relief, but I think also the prior challenge of ascertaining the scale of the remedial problem that the court has to solve. So in this sense, remedial formulation is a problem-solving exercise for the courts. Secondly, in relation to remedial implementation, the challenge for courts here is about promoting accountability for compliance. This may relate to the actual implementation of systemic relief, but it may also relate to the monitoring of compliance and the reporting back to the court about the progress being made with the implementation of systemic relief. And I think it's important to notice here that these two aspects of remedial formulation and remedial implementation don't always unfold in discrete stages, or indeed even in a straightforward sequential manner. Rather, they more often overlap in a dynamic way as part of a remedial process that may evolve, and the plan itself for remedying systemic violations may need to be refined in response to the many contingencies of implementation. And here by contingencies, I mean contingencies that flow from the fact that systemic relief is usually forward-looking. It's usually resource intensive. It requires cooperation and coordination between multiple actors. So the court's remedial plan then needs to be flexible enough to allow the continued tweaks, changes to the remedial plan in response to these uncertainties and contingencies of the remedial process. So the main takeaway here is that these challenges may require the continued involvement of the court in an extended remedial process. And so I use the word remedial process in this presentation really to underscore these continuities between a remedy and its enforcement, that there's no clear-cut separation. So navigating these challenges is a no easy task for the courts. In general, there's a kind of tension which they have to navigate, and that is, on the one hand, courts are bound by the constitutional imperative to provide effective relief for rights violations, and the Constitution also equips them with broad remedial power to do this. On the other hand, however, there are separation of powers constraints. So that means that the court is somewhat constrained by the limits of their democratic legitimacy, their institutional competence, and also the need to maintain their judicial independence. So the challenge for courts then is to provide relief that is both effective, but also an appropriate exercise of their remedial power. However, endemic non-compliance of the kind that we've seen more recently has placed increasing strain on the courts in this balancing act. On the one hand, there's a risk that rights are left unrealized, or at least under-realized. So this is a charge that remedies are ineffective and that the courts are ineffective. But on the other hand, there are increasingly claims of judicial overreach that are being voiced alongside criticisms that judicial remedies have been ineffective. And here, I think it's important to realize that I don't think the separation of powers envisages a system of interbranch checks that are completely frictionless. In fact, the Constitutional Court has often said that the court cannot rely on the separation of powers to avoid its obligation to provide appropriate relief that is also just and equitable. But there's no doubt that non-compliance does strain institutional comity between the courts and the other branches of government. And it also undermines the integrity of court orders. If anything, I think the weight of expectation that we've placed on our courts has only grown in recent years, as the courts are increasingly called on to step into the breach for government failures. And I'm aware that this is perhaps a sobering reflection to make just as we celebrate the 25th anniversary of the adoption of the final constitution. So it's in this context of increasing non-compliance with court orders and its corresponding strains on the courts and indeed our democracy that we're revisiting the issue of supervisory jurisdiction today. So I think it's safe to say, just by way of introduction, that early on, the Constitutional Court was reluctant to issue supervisory orders unless it felt there were strong reasons to suspect non-compliance. And even where the court did issue supervisory orders, it didn't generally meet with the kind of sustained or persistent non-compliance that has featured in recent cases such as Black Sash and Mwelase, which we'll speak about a little bit later. Drawing on the principles laid down in early Constitutional Court cases like the Treatment Action Campaign case, Kent Roach and Jeff Budlander have developed a remedial model to guide the use of supervisory jurisdiction and mandatory relief by the courts. And in doing so, they identify 3 reasons that they think commonly underlie government non-compliance with constitutional standards. And they then match these 3 reasons to weaker and stronger remedial responses. So the model justifies an escalating remedial response by the court over 3 levels. Firstly, where the constitutional breach can be attributed to inattentiveness on the part of government, they suggest that a declaratory order would be adequate, possibly coupled with public reporting requirements. Where incompetence is identified by the court as the root cause, they suggest that mandatory relief with supervisory jurisdiction may be more appropriate. And finally, where the government shows intransigence, they argue that a detailed mandatory interdict enforced by contempt proceedings would be justified. Roach and Budlander's key, and I think very valuable insight here, is that each species of governmental failure calls for a different responsive technique or remedial strategy. However, their model frames the reasons for non-compliance with constitutional standards in psychological terms, inattentiveness, incompetence, and intransigence. And these characteristics tend to align more easily with individual misconduct or states of mind. But I think as we increasingly aware, systemic human rights failures are often the result of institutional dysfunction or political blockages that are far harder to pinpoint or even categorize. And as recent cases like Black Sash and Mwelase have shown, it may be that government institutions have chronically failed to meet their duties, their human rights duties. And in fact, top officials even admit that much in court papers. So it's a different kind of challenge. And I think these more recent strains on the court require us to revisit and perhaps refine the remedial model that Budlander and Roach have put forward. And I think we need to aim to do this in 2 ways. First, we should look to capture more fully the range and complexity of institutional reasons that may underlie the systemic failure to fulfill rights by the state. And in doing this, I think we need to be attentive to the broader political context in which our courts operate, and that is the pervasive and systemic corruption that we see across state institutions. Secondly, I think a refined model should also seek to capture the greater diversity of remedial strategies that courts can employ. And this would include, of course, as we're discussing today, the emerging use of court-appointed experts and monitors. In considering the role of court-appointed experts and monitors, I think it's important to note that the emerging practice has really sought to couple the use of a court adjunct with still the retention of supervisory jurisdiction. So these things go hand in hand. And for this reason, I think it's useful just to briefly revisit the basic rationale for supervisory jurisdiction. First, the retention of supervisory jurisdiction has a procedural advantage. It enables the parties to return to court without instituting fresh litigation in the event of non-compliance. And in this way, it really facilitates the court's ongoing involvement in this extended remedial process. But secondly, the procedural function also has an important symbolic effect of inserting a continued judicial presence in the implementation of systemic relief. And I think this is in the sense that by the government department or institution having to anticipate going back to court to report on its progress and having to account to the court on its progress, that I think distracts in a productive way from that government entity's sense of institutional autonomy, and in a way that I think might promote compliance. So it's really this background presence of the court in supervisory jurisdiction that I think is the foundation of the court's accountability enforcing role in the remedial process. And so if we understand the purpose of supervisory jurisdiction in this way, I think we can make better sense of the role that court-appointed experts and monitors could play, and I think should play. Where the challenges of the remedial process strain the resources, capacity, competence of the court, it may turn to court-appointed experts or monitors to assist it. But importantly, in doing so, the court doesn't relinquish its control ultimately over the remedial process to these experts and monitors. It retains control. And these court adjuncts, which as the name suggests, their role is really to complement or supplement the court's supervisory jurisdiction. They are therefore appointed by the court and they remain subject to the court's control. And I think understanding their role in this way as an extension of the court's supervisory jurisdiction, I think is key to justifying their appropriateness. This means that there may be a diversity of functions that a court adjunct may be required to perform, but they're all united by their common purpose of ameliorating the court's supervisory jurisdiction. And this is not to say that anything goes, that anything would be an appropriate exercise of remedial power, but rather just that in appointing court experts and monitors, the appropriateness of that should be assessed in light of this rationale for supervisory jurisdiction. So just finally, to end with some case law illustrations, which I think really draw out these different functions that court experts and monitors may play. And really, I think it's key here to realize that public law litigation in the US has really led the way for the use of court adjuncts to administer and supervise systemic relief, or as it's known more frequently in the US, structural reform. Over the last 60 years or so, US courts at both the state level and the federal level have developed a diversity of very specialist functions that court adjuncts have played. These include a special master, as we are most familiar perhaps, but also monitors, mediators, administrators, and receivers. In this regard, I think state level analysis, comparative analysis between South Africa and US states is a very fruitful line of inquiry, given the greater similarities between the US state level constitutions and our constitution, as opposed to the sort of quite unique federal constitution in the US. And I think a very good example of this is the campaign for fiscal equity litigation in New York State. which was a very long-running litigation over a span of about 13 years, but it really culminated in the New York Court of Appeals with the appointment of a panel of experts to cost out, in budgetary terms, the constitutional standard of a sound basic education, which is guaranteed under the New York State Constitution. And I think this CFE litigation is a fascinating example for us because it deals with the polycentric issue of education financing, an issue that normally courts would seek to avoid or keep far away from. But here, the independent panel of experts facilitated a joint process of remedial formulation that was done through the input of all parties. So it was really collaborative, and this included the state defendants. The challenge here for the panel and the court was really not just that of expertise, which of course it was given the complexity of education financing formulas in New York and indeed across the US. But the challenge was also about the independence of the panel. This is what the real value was, because in this case, the independence of the panel was a way to break the political deadlock that had so far prevented a budget being passed by the state legislature, which was needed to comply with an earlier court order. The CFE litigation was really groundbreaking for many reasons, but including this reason of costing out studies having been pioneered. And since these costing out studies have been featured in many education financing campaigns around the US as part of what's often called the third wave of education financing litigation. That's not the third wave of COVID, but rather the third wave of education financing litigation, which in many ways is still trying to realize the elusive promise of Brown v. Board for equal education in the US. In South Africa, the earliest examples of court-appointed experts and monitors were really pioneered in the education litigation run by the Legal Resources Center. And it's really here in the lower courts, in the Eastern Cape High Courts, that the hard work of remedial experimentation and innovation was really done. So two of these cases, Madzodzo and Linkside, I'll just briefly illustrate how it was used in those cases. In Madzodzo, the High Court approved the appointment of an independent auditor to ascertain the furniture needs of schools across the Eastern Cape. And here it was both the expertise and the independence of the auditor that was required, as it became increasingly clear in the litigation that the department's own audit of these furniture needs was inaccurate and indeed perhaps could have been fudged. Madzodzo, however, is also a very good example of a court adjunct being used in remedial problem solving, because here the first challenge was really to ascertain the scale of the systemic relief required. So at a very basic level, the question was, how many desks and chairs do schools need across the province? Without that, it's very difficult to provide effective relief. In the case of Linkside, this was a class action, another case brought by the LRC. The High Court appointed a claims administrator to process class action claims. And this function, I think, is a far more straightforward example of a court adjunct engaging in an administrative function. It was really, first and foremost, a question of efficiently, reliably, accurately processing monetary claims that were owed to schools for their payment of teachers. But the first example, and I think perhaps that we're more interested in here, is the first use of court-appointed experts and monitors by our Constitutional Court. And this was first done in Black Sash, which was actually a trilogy of cases that followed in the wake of All Pay 1 and All Pay 2. In Black Sash 1, the court reinforced its supervisory jurisdiction with the appointment of the Auditor General and a panel of experts to evaluate compliance with its order, and then to file regular reports with the Constitutional Court. So here the oversight function of the specialist panel was particularly prominent. And I think Black Sash, for present purposes, powerfully illustrates how difficult it can be for the court to pinpoint the exact cause of non-compliance and then to assign responsibility for remedying the problem. It's difficult to identify specific public officials who were responsible and should be tasked going forward. And indeed, I think this is one of the reasons for Black Sash 2, where the court appointed a referee in terms of Section 38 of the Superior Courts Act to make factual findings as to whether the Minister of Social Development had acted in bad faith by withholding a full disclosure of her conduct to the court. And this, as we know, culminated in a personal costs order being issued against the minister in Black Sash 3. What's particularly interesting here too is, as the Constitutional Court has observed in another case in PECO 3, which Rolpa may speak about too, are the similarities between the referral process provided for in Section 38 of the Superior Courts Act and the US Special Master. There's some similarities there which I think are worth exploring. And it means that in addition to the court's constitutional remedial power, and indeed also the court's inherent power to regulate its own processes, there's also a statutory mechanism in Section 38, which could be used to greater effect in future. And then finally, the last case, just to briefly touch on, of course, is that the Constitutional Court itself acknowledged was a very bold and perhaps unprecedented use of a court adjunct, and that is the case of Mwelase versus the Director General for the Department of Rural Development and Land Reform. I won't go into much detail here because I think Rolpa may cover it in a lot of detail, but very happy to speak about it more later too. But for the moment, what I really want to pick up on is the court's characterization of the department's non-compliance. So just to quote very briefly from paragraph 40 of the judgment, Justice Cameron described it as follows. He said, the department has manifested and sustained what seemed to be an obstinate misapprehension of its statutory duties. It has shown unresponsiveness plus a refusal to account to those dependent on its cooperation for the realization of their land claims and associated constitutional rights. And despite repeated promises, plans, and undertakings, it has displayed a patent incapacity or inability to get the job done, which I think leaves little doubt there as to which way the court went. So finally, just by way of conclusion, to draw some of these threads together, I think the emerging practice in our courts of coupling supervisory jurisdiction with court-appointed experts and monitors is a fruitful way to start nuancing the typology first developed by Roach and Budlander, which remains a very valuable typology. But as I mentioned earlier, I think there's scope to nuance and build on. And I think this is for two reasons. Not only do these cases that I've briefly referred to introduce some novel remedial strategies, but I think they also illustrate the complexity of the institutional reasons for non-compliance. And so through, I think, more detailed analysis of these cases, the numerous returns to court, the reasons for non-compliance, I think we can enhance our understanding of what kind of responsive techniques or remedial strategies our courts really need in order to provide effective remedies. And indeed, I think really the real value of these remedial innovations in using court-appointed experts and monitors is not simply that in these cases they managed to, or at least partially managed to overcome non-compliance, but it's really that they were forged because of non-compliance. And I think this is where their potential lies as remedial innovations. It's in the fact that they were really addressing really stubborn challenges that courts often face when trying to remedy systemic violations of rights. And I think it's in this that the potential for their wider application lies as we seek to give full effect to rights. I think that's where I'll end for the moment, but very happy to take some questions, and we look forward to discussion at the end. So I'll hand over to Rolpa now. Thanks, David.
Thanks very much, Helen. Yes, I'm just going to introduce Rolpa. Thank you very much for your presentation and for, in a sense, engaging with some of these really fascinating questions. I'm sure there are going to be a number of a desire for discussion. Now, let me just introduce Rolpa, who will go further with this. Rolpa Fatsumapausa is an LLD candidate in public international law and a researcher at SAIFAC. As mentioned, she completed her LLB and also an LLM in human rights law. I was her supervisor and can attest to her deserved distinction for her dissertation. And her research generally focuses on constitutional, international, and human rights law. So Ropa, over to you.
Thank you so much, Prof. And thank you for that lovely introduction and for the opportunity to discuss this very interesting topic. I think Helen has laid out quite a substantial foundation for me to build on. And I'm very excited to just build up on that. And I'm excited as well because it's the first time that I presented an article that is going to be published by the SAJHR. So everyone gets a bit of a preview before the article actually comes out. And so let me just share my screen and we can get started. Okay. All right. So just to begin, I'm going to start off with a quote from, excuse me. All right. To start off, I'll start off with a quote from Minister of Health versus Treatment Action Campaign, which states that South African courts have a range of powers at their disposal to ensure that the Constitution is upheld. And these include mandatory and structural interdicts. How they should exercise those powers depends on the circumstances of each case. Here, due regard must be paid to the roles of the legislature and the executive in a democracy. What must be made clear, however, is that when is it appropriate to do so, courts may, and if need be, must use their wide powers to make orders that affect policy as well as legislation. So I believe this particular quote really encapsulates everything that we've been discussing today. It points out the powers of the court, but it also points out what the limits of their powers are. But it's also a very controversial quote because to some extent, it speaks to the fact that courts may need at times to encroach into the sphere of the executive in terms of practicing judicial review. And so just to start off, the aim really of my presentation is to examine the form of structural interdict, which relates to the use of the expert remedial formulation model. So while Helen has spoken more extensively on the use of experts and the use of certain types of monitors, I want to focus on how courts usually actually resort to the use of experts to implement their decisions. And so I'll start by outlining some of the models of a structural interdict, how the expert remedial model has been developed in South Africa, and how the employment of monitoring mechanisms is used in foreign jurisdictions. Since Helen is charged on the USA, I'll be touching more on Colombia, and I'll also be touching on how the expert remedial formulation model has been used in India and Colombia. And so the reason why there are so many models of the structural interdict is because it is such a flexible type of remedy, and you can actually develop it to meet the circumstances and the various situations that you need in terms of how they demand remedial efficacy. So the different models are also imperative for the realization of key features of decision-making and the promotion of dialogue between government branches. So the different models include the bargaining model, they include the report back to court model, which Helen has also touched on briefly, and the legislative or also known as the administrative hearing model. So the differences between these models really is in the steps that the courts usually employ to monitor or exercise oversight over their decisions. So with the report back to court model, it comprises of a number of stages that must be procedurally complied with until the court is satisfied that a particular violation has been remedied. So it is only after the court has issued orders which compel the court to comply with its constitutional obligations, the court is then required to report back to the court with a proposal of how it intends to remedy a violation and continuously mitigate the violation. With the bargaining procedure, it is a form of procedure that takes place between the lawyers of the parties or the litigation parties in a particular matter. And these lawyers have to come to an agreement in terms of the remedy. So it really involves the use of the interest of stakeholders, and they then have to submit a proposal as to how a specific right will be remedied. And then lastly, with the legislative or administrative hearing model, it is a form of model where the court conducts a series of informal hearings which allow persons who are not party to the litigation necessarily to participate in informal hearings. The objective of the informal hearings is to allow a different set of interests to join the inquiry in order to determine the most appropriate and effective remedy. For the purposes of this discussion, my focus is on the expert remedial formulation model. This model involves the appointment of experts by a court with a mandate to design a specific remedial plan. The court can alternatively order the appointment of an individual. So it's not always a panel of experts. It can even be an individual who is known to the court, and they bear the responsibility of coordinating a panel of experts. Depending on the order of the court, the role of the expert will differ. Sometimes it's to formulate an appropriate remedy, sometimes it's simply to ensure or to oversee the implementation of the remedy. So unlike the other models, a key advantage of the expert remedial model is that it actually involves someone who's got expertise that a court may not have in the creation or framing of issues or the proposal of a remedy. This means that an expert can actually address the systemic incapacities in a government or in a specific institution. And just to build up on that, this is perhaps one of the most interventional model into the work of the government. And so it's been criticized by academics, it's been criticized by even some members of the judiciary for encroaching into the sphere of the executive. However, the court, because one of the key issues that comes with this particular model is that it does not directly contribute to the formulation of the remedy, but rather the experts are actually tasked with consulting with the parties, and other branches of the government can also be consulted. So to that extent, I would personally argue that it does not necessarily violate the separation of powers, because other branches of government are not excluded from the consultation process. And so just to highlight a number of cases where this model has been applied in South Africa, I think that just to highlight that our apex courts have been very reluctant to actually use this model. So there are very few cases where you find that they've actually appointed experts to monitor their decisions. And one of the cases has been highlighted by Helen already. It relates to, is the Black Search Trust case. I'll be focusing more on the constitutional court case. And in this case, as Helen actually outlined, a range of remedial mechanisms were used to enhance SASSA's compliance with its constitutional obligations. And so the court supervision was complemented by extensive reporting requirements. So for instance, the court actually first mandated the minister and SASSA to file regular progress reports with the court and to detail compliance with the timetable of deliverables. And it was only after SASSA failed to comply with these reports that the court appointed monitoring mechanisms. And so it jointly appointed a number of experts to oversee the implementation of the process and to assess the steps taken or envisaged to be taken by SASSA in the competitive bidding processes. And it also, the monitors were also required to evaluate the steps envisaged in the administration and paying the grants in future. And in the Mwalesa case, I'm just gonna go a bit more in detail with this case since Helen touched a bit of base on that. The background of the case really starts with Section 16 of the Land Reform Act, also known as the Labor Tenants Act, in which a labor tenant may apply for specified property rights. And so a number of applications are submitted by labor tenants. However, the Department of Rural Development and Land Reform failed to process these applications due to having backlogs. And so the Legal Resources Center launched litigation on behalf of the applicants in the Land Claims Court, challenging the department's enduring and systemic failure to process their applications. Amongst other things, the LRC was asking for a structural interdict, which would direct the department to provide statistics detailing the status of all labor tenant applications. And it was also seeking for an order that the department must report regularly on its progress to the LCC until all outstanding claims had been settled. So as you can see in the beginning, what was actually asked for was a report back to court model. However, the department repeatedly failed to provide relevant statistics in spite of having agreed to provide or present the statistics by a particular date. And so the LCC was approached 2 years later and asked to appoint a special master. So a special master is also a sort of expert, and this is an independent person who is appointed by and reports to the court. His or her duty is to assist the court according to the mandate that is actually set by the court. And this person, again, has expertise in specialist areas of government, and they assist with devising a remedial plan or implementing it. So this was the order that was sought after the report back to court model actually failed. And so the Constitutional Court made it clear that following the decision of the Land Claims Court, which actually agreed to appoint a special master, the special master was to remain an agent of the court and act in extension of the court's supervisory jurisdiction. The reason why it's such an important phrase by the Constitutional Court, it relates to most criticisms that were raised against the appointment of the special master. First, by the Supreme Court of Appeal, which actually overturned the appointment of the special master, arguing that it violates the separation of powers. And again, the similar arguments were raised in the minority judgment by Justice Jafta, who raised the question of judicial overreach. In his view, parts of the majority order extended beyond a constitutionally permissible intervention by a court in the performance of administrative functions. But it's interesting to know that Justice Jafta was not really against the appointment of a special master. His issue was rather that the LCC's order, that is the Land Claims Court, the order of the Land Claims Court differed from orders previously granted by other courts, as it required the special master to prepare a plan which entails the determination of a budget. So according to Justice Jafta, the determination of a budget was one area that should specifically be left to the executive. So he raised the question of judicial overreach in as far as the special master had powers to oversee the determination of a budget. And I just want to highlight the arguments that were raised by the majority judgments in response to the criticisms for the appointment or the powers of the special master. The majority judgment took the opportunity to highlight that the independence of the special master is really an extension of judicial independence, because the special master derives power or derives his authority from his appointment as an agent of the court, and therefore he is continually subject to the court control and authority. And so the special master is not an unaccountable body, and so any powers or any functions exercised by the special master are not an intrusion into the executive domain. Instead, the court appointed a mechanism to ensure that the nationally critical land reform and restitution processes become effective. And so in response to any criticism raised against the power of the special master, what the court really sought to highlight was the need for the special master, the circumstances that brought about such an appointment. And in this case, that relates to institutional dysfunctionality and also incessant non-compliance with the court's orders. And so that was really the response to any allegations that were raised of judicial overreach. Now, the expert remedial formulation model has also been used in foreign jurisdictions. And I'll start by highlighting the appointment of monitoring institutions in Colombia. The reason why Colombia is such an important jurisdiction and why I chose to highlight the appointment of experts in Colombia is because the Constitutional Court of Colombia is actually very interventional. It's one of the few jurisdictions that always goes for strong remedies, and its constitutional dispensation is very similar to South Africa's, but it always seems to go for a judicial activist approach and is more daring and more bold about challenging the executive. And in the T760 judgment, a number of cases were brought together by, it was about 22 cases brought, which were challenging a number of structural problems in the Colombian healthcare system, particularly in relation to access to healthcare in Colombia. And so in response to these challenges, the court issued a set of structural injunctive measures or remedies, which included the employment of an expert remedial formulation model, in which the court actually ordered the Ministry of Social Protection and the National Superintendents of Health to fulfill their obligations by identifying institutions that frequently refuse to allow health services. But the court also went a step further and appointed an ombudsman and the Attorney General of the nation to monitor the ministry and the superintendent and to supervise the measures that would be employed by these two institutions to ensure the effective enjoyment of the right to health of persons. I think it's just interesting to note as well that following this decision in the T760 judgment, there was a very slow, there was actually very little increase of cases relating to failures in the healthcare system following the cases, just to show that the measures that were implemented following this case were so effective that it is so rare to actually find any cases that question or that relate to the failure of the healthcare system. And this is one of the benefits of having a monitoring mechanisms that ensures that when there's a court order, it is actually implemented. And it's interesting to also note the approach of the Colombian Constitutional Court in terms of appointing experts, because there's an evident pattern where the court begins with relatively open-ended orders, both in terms of substance and the timeframe that is given for compliance. And it is only when these orders prove to be ineffective that the court adopts more innovative remedies and gives detailed orders, which may include monitoring mechanisms. So at the time of the T760 judgment, most of the cases that came before the court had been decided before, but without any monitoring mechanisms. And so it was only following the failure of the state to comply with earlier orders that the court made the decision to appoint experts and specifically monitoring mechanisms to ensure that certain institutions would actually implement the orders that were necessary under the circumstances. So Tashnet points out that this sequence of starting with open-ended orders and moving forward to stronger remedies is important when designing effective areas in this area, designing effective remedies in the area. Courts may, for example, want to begin with broader solutions, moving towards firmer remedies as they gauge both the political reaction to their orders as well as the response in a complex area of policy. Now, a similar approach is also followed in India, which is also very well known for its judicial activism. And for the purpose of this discussion, I'll highlight the People's Union for Civil Liberties versus Union of India and others, which is also known as the Right to Food case. So this case, just to give a brief background, took place initially against the Food Corporation of India, which operated reserves for storing grains. And at the time of the case, the reserves of the Food Corporation were 40 million tons above the required buffer stock. But because the grains were being kept outside the reserves, they started to rot due to the rainfall, and they had to actually get rid of most of their grains. But just 5 kilometers away from the reserves, there were people who were experiencing drought and facing starvation. And so a petition was brought before the Supreme Court of India seeking recognition and protection of the right to food. The interesting thing about the case is that at the time that the petition was brought, the right to food was actually not recognized under the Indian Constitution. However, the Supreme Court interpreted the right to life as the right to live with human dignity and all that goes with it, namely the bare necessities of life, such as adequate nutrition. And so the right to food was incorporated into Article 21, which caters for the right to life. While early interim orders of the court were focused on the public distribution of food grains to families and persons who fall below the poverty line, the court later appointed a commission as part of its constitutional mechanisms in 2002. Again, this was following a number of flaws or unwillingness to implement the court's order, and so the court decided to appoint a commission. And the role of the commission was to monitor the effect of the interim orders on the lives of the affected people and to propose changes and report to the court. The commission was also empowered to carry out investigations into any violations of the interim orders and to demand redress with the full support of the court. The commissioners also took part in the negotiation and mediation of law-changing policies and programs together with the state. So there was really some sort of dialogue or teamwork happening between the commission and central governments to ensure the improved implementation of the feeding schemes. So a number of similarities will stand out to me between the approach of the Colombian Constitutional Court, the South African Constitutional Court approach, and also what the Supreme Court of India implemented in terms of retaining supervisory jurisdiction. It is, first of all, independent from the description of the Commission's duties that the Supreme Court established the institution to ensure compliance with its interim orders. And I believe Helen has touched on this, that one of the reasons why experts are appointed or supervisory jurisdiction is exercised is really to ensure compliance. And that is the main case where the executive is unwilling or unable to comply with interim orders, and so monitoring mechanisms become necessary. And furthermore, the jurisprudence of the courts, really all the courts I've discussed, shows the willingness of the judiciary to adopt monitoring mechanisms if broader constitutional rights are affected by incessant non-adherence of the state. And the approach that is evident from all of the cases that have been discussed is the fact that the courts always start from a very lenient approach, and it is only when they're absolutely forced to that they choose to adopt the expert remedial model following a series of weak form remedies. And so a number of criticisms, as I have indicated, arise from the approach of from the approaches that are taken to supervise the implementation of court orders. And so, for example, we've got Filion and Makama arguing that the employment of monitoring institutions in India is an example of an intrusive form of structural relief, as the courts overtake the decision-making powers of bureaucratic institutions over extended periods of time to restructure such institutions. I argue that this legitimacy argument stems from the view that the allocation of resources and decision-making should be left to the executive and the legislature. However, the realization of human rights, in my opinion, cannot be left exclusively to politically elected authorities. And this goes back once again to the quote that I began with, which states that there is specific roles for the executive and there's also a role for the judiciary. However, in certain instances in where it is absolutely necessary, the judiciary must intervene and ensure that the steps taken by the executive are reasonable and are able to effectively vindicate any infringement of fundamental rights. Therefore, although the state enjoys a large discretionary power in terms of adopting policies for the realization of rights, it is a duty of the judiciary to determine how these measures or policies are implemented. And so, just in concluding, the appointment of commissioners or experts, in my opinion, should not be viewed as an encroachment on the sphere of the executive, but rather as a necessary response to systemic failures which aimed at assisting the executive in its functions. And once again, just to reiterate, I do not argue that the expert remedial formulation model is the only model that is capable of achieving supervisory jurisdiction. I believe that all of the models that I indicated earlier can actually be used in complementarity with each other, or only when one model fails and it is necessary to upgrade and ensure that the state complies with court orders. So I'll end there. Thank you.
Thanks very much, Ropa, for the presentation, and thanks to you both. I think for examining this topic in some detail with a comparative perspective, as well as some theory as well, and engagement with the question of separation of powers that it raises. So we have a number of people. I know some people here are involved in litigation in areas, others in various forms of academic theorizing who've joined us today. So it's I would like to open the discussion, and you're welcome to raise your hand. You're welcome to put your comment in the chat. And as I say, we're a relatively small group, so it's also, I think you can feel free to ask a question yourself. So, yes, let's open up. Yes, I see Professor Kathy Albertine Kathy, you're welcome to take the floor. You can just, I think you're just able to unmute directly.
Yeah. Thanks, David. So yeah, my question is, I think I agree with the arguments that have been put forward, and been looking at some of the US stuff on their structural processes, on institutional reform. So my question really is, does this work? I mean, if you, it's all very well to say this is permitted, and these are really good remedies to be asking for, but when you're dealing with an incredibly dysfunctional state in some places, does it work to put in a couple of experts to achieve a particular remedy? And are there conditions under which it may or may not work? That might be the next phase of your research, so I apologize if I'm asking a premature question, but I think it's a really important one.
Yes, it's a great question. I think I'm going to take I see another hand, so Rolpa and Helen, you can prepare your responses, and Sasha Stevenson.
So much to the both of the presenters. I'd be interested to hear your views on whether we as public interest litigators should be looking to kind of start a bit further along the remedy train, as it were. What we're experiencing is when you get a supervisory order that requires report back to the court, of course, really what that means is report back to the litigants, and it requires an astonishing amount of monitoring and ongoing evaluation by public interest litigants. That, you know, that's part of our role, but it also is very resource intensive. And I wonder what you would think about an argument to say, well, let us rather argue first off for the appointment of an independent auditor or body to conduct some of that monitoring work on behalf of the state, to lift some of the burden of public interest litigants.
Okay, a very fascinating perspective. Yeah, and actually not just displacing the burdens. Great. So these are a good start, and I'm sure others also want to intervene, but I'll sort of give an opportunity to our two panelists to engage. Perhaps let's go in reverse order. Rolpa first.
All right, thank you. I'll just start with Kathy's question. Thank you so much, Prof. Albertson, for the question. Just to respond to whether it works, I think it really depends. Again, to a large extent, unfortunately, you still rely on the willingness of the state to engage, because there needs to be dialogue between the experts and specific state institutions. So once again, in South Africa, particularly with the cases that I've looked at, for example, with the Molasi case, it took a while for the department to actually get to processing the applications, and even then, it was not to the full extent that the court expected. So it relies, as I say, on the willingness of the state. But I think the really important part of the expert remedial formulation model is the dialogue that takes place between the two different branches, and it allows the state to come up with a remedy that it feels it will be able to comply with. So to that extent, it contributes to the effectiveness, because if there's a branch, you say this is the measure that we're able to actually implement, then to a large extent, we expect to see success in that regard. And then to the second question, I actually agree that in most cases, the expert remedial formulation model should be used first. But as I say, there seems to just be a pattern in our course that you start with a more open-ended approach, and only when that fails, you move on to the expert remedial formulation approach.
Yeah, that's an interesting one, Rolpa. I think that sort of raises a number of challenges, whether you should jump into a strong remedy or whether it's not a good thing to actually start at a lower level of remedial strength and move up the chain. So essentially giving the state time to comply, but then becoming tougher as the case may be. Helen, your thoughts on the questions?
Great, thank you. Yeah, fascinating questions, and I think really tough ones. Perhaps just to briefly add an answer to Professor Albertain's question on does this work, and I think that really points to a major shortcoming, I think, in the literature, which is that research on remedies is very theoretical, and indeed I was in some ways very guilty of that today. But I think remedial theory needs to be really attentive to remedial practice, and that doesn't come easily to us as academic lawyers. We tend to focus on theoretical and doctrinal research, and I think a lot more empirical research needs to be done on the follow-up. And I think particularly in South Africa as we experiment at this stage. So for instance, I think Mwelase is a real opportunity that we should follow up on to really track how the special master plays out. And so, for instance, I'm aware that a special master was appointed, and my understanding was that that person, Professor Richard Levine, actually was very well received by both parties, both state parties, by AFRA, as well as the LRC, and comes with huge amounts of experience and in government and out of government. And the question is, what's happening now, a year and a half later? So I'm aware, for instance, that I think by April 2020, a remedial implementation plan was meant to have been formulated. And the question is whether that's been done yet and what's come of that. I don't know. And this is something I've researched, been interested in. So I think that's very telling as to a shortcoming of research and being very focused on the kind of theoretical questions about, what is appropriate for courts to do and what is inappropriate. So I think it would be very valuable to do more work on that empirical side. And I think particularly in remedies, that really one can't develop a theory of remedies without being attentive to practice and the complexities of actually implementing remedies. So I think that's a big shortcoming. So yeah, I admit that fully. On the second question, on Sasha's question, I think is also really interesting, and Rorpa's given her perspective on it. Again, just from the literature, one thing that really catches my attention is that there's a real preoccupation with limiting the court's power, to saying, no, the courts shouldn't go too far. But there's not equal attention given to what is the optimal remedy at any stage of litigation that should be given. So even if it is at the first stage, maybe one doesn't grant a very intrusive remedy. You don't appoint an independent monitor or expert right up front, but you may want to build in sort of more stronger reporting requirements so that you are able to track compliance. So I think, upfront, there are things that can be done. It might not be the most intensive or intrusive remedial mechanism, but it's at least allows one to pick up non-compliance early on, so that it doesn't kind of escalate into these kinds of serialized litigation that we often see. And I think linked to this is perhaps really the answer to Professor Albertain's question as well, is does this work? I think if it does work, if something like in Mwelase, the Office of the Special Master proves to be effective, then there's a strong argument to be made that this should be institutionalized in some way, that as an extension of the court's powers, that on an ongoing basis, there's more robust oversight over the implementation of court orders. And that's moving into a different kind of terrain that involves, I think, broader questions about the role of the court and institutions. But I think it's one worth raising. On the costs point, that was an argument very forcefully made in Mwelase that the special master would have to be paid. This was a huge amount of cost. And I think the LRC really rebutted that very well by saying, one loses sight of the fact of the hidden costs involved in continually going back to the court every time there's non-compliance. That's also the court's resources. Mwelase again bears it out very well. I think there was, every return to the land claims court 6 or 7 times, it came before about 4 or 5 different judges. Every single time you have a different judge who has to familiarize themselves with the matter. It's huge strain on the court's resources. So in terms of costs even, I think there's a strong argument to be made that we shouldn't be placing this huge burden on civil society and the strength of the public interest litigation firm that you have assisting you or not. That then becomes, has its own kind of effects on the inequalities of access to justice that I think we should worry about. So I think there are many different interesting concerns and challenges to raise there, but very important question. Thank you.
Thanks very much. Yeah, and your idea perhaps raised the question for me whether we should actually think of a branch or not a branch, or perhaps a dimension of court, which is like, I suppose, similar to like a sheriff, but that actually in the public sector, in a sense, is a permanent compliance mechanism of some kind that look, particularly in global South countries where there's there's high levels of incapacity. But perhaps that's something you can think about in answer. I see we've got a question from Professor Darby de Villiers. Darby, please go ahead.
Thank you, David. Can you hear me?
Yes, we can hear you well.
Thank you. Thank you for the presenters, very fascinating, and their recommendations really great. I would like to link onto Kathy's remark to say, you know, what should be done and what is being done, especially from a practical side. You know, and Helen touched on the cost side. You know, budget constraints is a huge issue when you try and get experts, because they do not come cheap. My other practical question is actually a more serious one, and that is the choice of the independent experts. You know, should the parties be involved to come up with suggestions? Sometimes, you know, that we talk about independent or we talk about objective, but nobody can be 100% objective. So one party would prefer expert Professor Dr. X, another party would prefer Professor Dr. Y for their specific reasons. So my question is, what should be the role of the parties to come up with recommendations to the judiciary, in other words, to the judge or the magistrate, to say, we would like to suggest A and not B, and eventually, that is my question. What should be the role of the parties in recommending a certain so-called independent expert? Thank you, David.
Thank you very much. That's a fascinating question. I'll be interested to hear our panelists' responses. Anyone else want to come in at this point? So we have another question. Anyone else got some burning issue they want to raise about this? I mean, it is a fascinating kind of remedial approach. Perhaps if no one's coming in, Helen, I wanted you perhaps to elaborate a little bit about the revision of the Budlender model and Roach model, and a little bit more on what you think systemic, and it perhaps relates to what was said by Kathy and also for Ropa in a way, is the circumstances in which systemic abuses justify these kinds of interventionist remedial approaches, and can we better on the inattentiveness, intransigence kind of incompetence model. Okay, so Helen, perhaps you start and then Ropa.
Sure, thank you. So just on the first question, the choice of expert, and Ropa may well know a lot more than me about this, but my understanding is that there are quite a number of different models for how that could play out, the choice of an expert or monitor. And certainly in the US, I think they've sort of quite detailed guidelines for this aspect. In South Africa, I think obviously we're experimenting, and my understanding so far, certainly in Mwelase again is a kind of recent example, is that the parties could put forward their own recommendation for who that should be. And ideally one would have a measure of agreement, but ultimately the court necessarily has the final say. Again, my understanding in Mwelase was that both parties were very happy with the choice. So it seemed like they saw eye to eye. But as I say, I don't know what's happened since then. Maybe they've had a falling out like they did over the course of the litigation. But certainly there are different models. I think it also depends on the matter. I think it really depends on what kind of independence, and as you point out, you know, objectivity or independence is kind of a relative concept. But when I use it, I mean independent as in representing the court, rather than necessarily independent from political affiliation or anything like that. So I think it's about what is the function that's required, what kind of expertise or independent decision making, and here again we're concerned not with policy making, but really enforcing rights that the court has already said. You know, what the normative requirements are for compliance, you know, what that must involve, so that there shouldn't be much debate at a policy level. So it's really about independence in the sense of representing the court. Just on David, perhaps just to follow up on your question, I mean, I must admit that this didn't form as much part of my doctoral work as I may have made it appear today, but So I haven't, really come up with a fully fleshed response to Roach and Bundle. I think at the stage I've just kind of picked up recently that perhaps we need to revisit it. And I thought that's what I would raise today. But I have argued elsewhere for really a greater emphasis to be placed on the way that courts reason about remedies. And, the courts always have a duty to give reasons for their decisions, but I think that duty is underscored in the context of the discretionary nature of a court's remedial power. So they really need to give strong reasons for why they're making certain remedial decisions over others. And I think that really comes into its own in this context. If it's going to choose a certain kind of expert or a monitor, it needs to carefully reason why it's appropriate in the circumstances and what the particular kinds of challenges are that it's seeking to address. Not just an expert as a kind of generic, sort of knee-jerk reaction, but really carefully calibrated to the kind of institutional problem that has been addressed. So I'm kind of leaning in that direction, but and I've kind of done some work on the remedial reasoning side, how courts might want to reason through that, but I haven't as such developed a kind of typology of the reasons for non-compliance.
When the circumstances will be, fascinating. Ropa, over to you. Any thoughts on the independence of the expert, etc.?
My thoughts are really more or less the same as Helen's in this regard. I completely agree with everything she said. For me, I'm a bit wary of the parties being responsible for choosing a specific expert, because as the role of the expert involves coordinating the stakeholders and consulting with them, it would be very easy to influence a certain expert if he or she is chosen by one of the organs. So I'm very worried of that. But I do know that recommendations are made before an expert is appointed, as Helen pointed out. But I think an alternative to achieving maybe a balance for everyone in terms of the appointment of an expert is maybe where a panel of experts is appointed, and then everyone gets to recommend and everyone's considerations are taken into account before the panel is actually established.
Yeah, so it's an interesting question whether it should be done, as I sort of raised, whether it should be done ad hoc or whether actually we should have a kind of judicial enforcement arm of public remedies. I mean, that may be the next sort of proposal. I don't know if it's a constitutional one or it could, I suppose, be created by the courts in some sense. But I suppose independence would affect, you would be able to perhaps in a more institutional one guarantee it in a broader way through also encouraging diverse voices than in relation to an ad hoc one, which is more difficult to accomplish as well. But you perhaps, and so I suppose, and you have to have grounds on which you target, in a sense, the remedial efficacy. Well, we are actually at the end of our seminar time, so I'm very happy if someone wanted to ask a last question, but otherwise, we, I think, have had a really interesting expose into the discussions around supervisory interdicts and these new remedial forms of court-appointed experts. I mean, there are a range of others that the South African court hasn't experimented with. I think, Ropa, you usefully outlined them. I know in Colombia, they've actually had sort of panels of experts to discuss a problem and actually sometimes referred the resolution to a panel of experts, in fact, and tried to address crises in the society which are not properly being addressed by the government. So these are maybe things that will still come up in the future. I think this is, in a sense, a discussion that's only just begun. I think we've seen widespread systemic incapacity in the state. And so my anticipation would be we're going to see more of these interventionist remedies. And the question, of course, is how far can the judiciary go in a way to become without taking over the role of the executive in a sense, enforcing compliance with constitutional rights and with government's responsibilities. But certainly, as I say, with the increasing problems in the state, I think we will see more of this, and no doubt more legal research. I think, as we've heard, in a way, some of the normative side is the researchers have dealt with, but I think there's actually a lot of interesting empirical projects which we often aren't that good at doing, but perhaps these are the ground of future research projects. So thank you to Helen and Rolpa. We look forward to welcoming you as our future seminars, and wishing you all well. And to those of our Muslim attendees, Eid Mubarak. Take care. Bye-bye.
Thank you.
Thanks.